Good morning. Again, good morning. Welcome. This is our monthly webinar. We're happy to see you attending today's seminar. It is a great turnout. My name is Angela Lopez. I'm a shareholder and practice head of immigration group at Cowles Thompson.
And I'm Michelle Alonzo. I'm an associate attorney here at Cowles Thompson.
And today we're going to be talking to you about J-1 waivers, understanding the 2-year home rule requirement, and other things. For just a few housekeeping items, if you can please note that we are muting the phone. So during our presentation, you're not going to be able to ask questions or others. You might type your question on the pen, but we will not be able to hear you. At the end of the presentation, we will open the lines for questions, so you will be able to ask your question. If you want to start writing them down throughout the presentation, you're welcome.
For the audio, they'll need to put in their audio pin to talk.
Okay, and at the end of the presentation, when you want to talk, ask your question, you will need to put your audio pin so you can be heard. Thank you. And we'll go through these little reminders at the end when we open for Q&A, the Q&A session. So today, the presentation, we're going to go with a little information about waivers and understanding the 2-year requirement, questions and answers. For some of you who regularly attend this webinar, this topic is kind of familiar. We try to do it at least once a year for obvious reasons. Every year we have new physicians who are graduating from residency or fellowship programs, and they all want to know about the J-1 rules and requirements. We also have physicians who have done the J-1 waivers, and they are now in the H-1B phase, complying with, and they still want to kind of understand or have a refresher of the 2-year home foreign residency requirements. So we try to refresh the information with the latest news. Thanks God, this is one of those programs, or not thanks God, because I think it can be improved in so many different ways, but this is not a program that is constantly changing as some of the immigration programs. So some of the information you're going to hear today, we have already covered previously. So we, again, every time we do this presentation, we tell people we start with this beautiful graphic. Believe me, we didn't come up with this graphic, unfortunately, because we think it's genius. It was actually the agencies who came up with this graphic. And basically, it kind of outlines and shows the path or the process a medical graduate goes through to finally achieve permanent resident and ultimately citizenship. It all starts with a medical school, an MD degree, and it could be a U.S. medical school or it could be an international school. Doctors or physicians who come from other countries with medical schools, they are often referred to as foreign medical graduates, or FMGs, or international medical graduates, IMGs. So either way, it is an international doctor or MD. Then then you go to the residency programs, and we say residency because even if you do a fellowship at a later date, you always have to start with the residency program. That's a U.S. requirement if you want to practice as a physician in the United States. And then for residency programs, you can be either a J-1 or an H-1B, and from there you are subject to a bunch of different things. If you're a J-1, then the path is going to be a little bit longer than if you come in as an H-1B. However, for H-1B, there might be certain limitations, so you need to be aware of those things. And finally, once you get your green card through whatever method, if it is employment, then you have to wait 5 years to get the citizenship. But if you get it through a spouse, you may only need to wait 3 years. But this is a pretty good overview of the different steps to get to citizenship at the end of the day. So understanding the 2-year foreign home residency rule, it sounds straightforward. Basically, it is you have to go back home once you complete your residency training. Hold on, I'm having issues with the PowerPoint. Okay. So basically, you have to complete the 2 years for a residency, which is defined as you go back after you complete your residency or training, home, you have to return home country for 2 years, or you need to obtain a waiver before you can apply for H-1B or permanent residence. So if we're talking the home country, what does that mean? Home country means that you have to go back to last place of residence. Last place of residence, which means where you completed your school or where you were residing at the time the J-1 visa was granted. It might be different from your home residence because you might be, and the perfect example, like we have some physicians who, for example, they were born in India or Pakistan or the UK or Argentina, and then they go to medical school in Canada. So if there is where they were at the time the J-1 visa was granted, then they're supposed to go back to Canada instead of Pakistan or India or Argentina. Or
Right, and
those countries.
that's one of the things that we get a lot of questions about, because there's confusion as to whether it's your home country, your birth country, but home country is defined, as Angela explained, it can oftentimes be different from your country of birth.
Yes. So what do they mean by 2 years requirement? Full 2 years is 24 months.
So
not 1 day less.
I was about to say.
Yes, and we have physicians or people who ask us, well, what if I complete this, but I have the opportunity to come 1.5 years into it? No, it is a full 2 years, 24 months, nothing less.
No substantial compliance.
No substantial compliance
full
or
compliance.
part-time or kind of halfway compliance. Is full compliance. And does not have to be fulfilled immediately after completing training. What that means is, for example, you had to leave the United States after you completed your training because you didn't find a way to stay in the United States after you completed your training, but then you went somewhere else to do more training or to work or do something else rather than home country or last place of residence. That's fine. You can then later on go to your home country, stay there for 2 years, and then try to do something else. Same for the J-1 waiver. If you leave the United States, you may not go back to your home country. You may go somewhere else. But in the process, you get an employer who sponsors your J-1 waiver. They can do your J-1 waiver so you can come back to the United States even though you never went back home. So it's either you stay the 2 years for as long as it takes you to complete the 2 years in your home country, or you get the waiver even if it is a few years after you complete your training.
So, question, Angela, if I was in my home country, for a year and 9 months, but I went and took a 2-month vacation through Europe. I wasn't home, but I was in Europe on vacation.
Yeah.
Do those count?
No, because we're talking 24 months, so there's going to be a little break. What that doesn't, they will not hold against is, for example, if you take just a few days here or a few days there, but when you take chunk of times, that's not going to be counted as being your home country for the full 2 years.
Huge distinction.
Because people take vacation.
Yep.
And usually vacation is a week or two, not 2, 3, or 4 months.
Well,
I wish we had this.
A couple of countries, they take holiday and they take a long time, and it's great, but I think it is important to note that distinction.
Yeah. People can return to the United States in B2, B1s, F1s, H1B. Listen to that one. O1, F1. And that H1B just be careful with that. We're not saying that you can just leave the United States, although being subject to the 2-year foreign residency, go and apply for an H-1B and come back. That is only for example, physicians from Canada, that they don't have to go to a consulate to obtain a visa. They just cross the border, and at the border they will admit them, and whatever status they're coming in, if they are coming in H-1B, even though they don't have a J-1 waiver, they are usually normally should be allowed to come into the United States to work in H-1B. The problem there is that later on, they will have to demonstrate either they got a waiver or they resided back home for 2 years before they can get a green card. So they can stay on H-1B for some time, but they won't be able to do much unless they get that waiver.
So they're just delaying the fulfillment of this 2-year requirement or the waiver.
Correct. Now, 3 types of J-1 waivers. We're going to talk about what are the J-1 waivers options for physicians who are subject to these 2-year rule. So, Michelle?
So you'll see right there on your screen, we've listed the J-1 waiver options, Conrad 30 state program, the VA program, Department of Health and Human Services. You'll see them up there, Appalachian Regional and Delta Regional. We're going to break these down here in the following slides. If you've heard this before, as Angela mentioned in the beginning, it's always a great refresher to be aware of these various options. So Conrad 30, one of the more popular ones. 30 slots are allowed per fiscal year, and remember the fiscal year for these purposes is going to begin October 1st. A lot of things happen October 1st. That is going to be when everything would start, but you're going to be looking at your timeline to start well before that. And according to each state, there's going to be varying deadlines and opening dates, and you'll see in a future slide we've listed out those are. You're looking at HPSAs or MUA, so health professionals and practitioner shortage areas or medically underserved areas. Why is this important? The heart of the J-1 program is to try to get medical professionals out to these areas that do not have regular access to medical care. The contract requirement is going to be a 3-year requirement. So you're trading your 2-year home residency requirement for this 3-year minimum contract requirement, and it's generally going to be primary care. Specialty care is allowed for various states. We have to look at that in particular. We've listed there the websites that you go to check to see if it's a HPSA or an MUA. And then you'll pay attention there. There's 10 flex slots also available for non-underserved areas. These are highly sought out. And so, but we mentioned that because it is available.
Yes, and basically the way that works, just to give you an example, is if you have an employer who is going to sponsor you J-1 waiver, but the employer itself, the location of the employer, it's not in an underserved designated area, HPSA, MUA, or MUP, then if that's the employer's location. So, but if your specific work location, meaning the physician's work location, like, for example, is a private practice, and the physician is going to be working at a hospital, and the hospital, or not working necessarily, but spending most of his time at a hospital that serves the population, the underserved population that it is around the hospital, then that is a flex, meaning you might be working at a place that is not located in underserved area, but you're going to be serving the population. However, some states apply these rules differently, and they do see flexes as not necessarily locations that are not underserved, serving the underserved population, but locations that might not be HPSA, but might be MUAs or MUPs. But the flex is kind of a hybrid, kind of a little program that allows physicians not to necessarily be with an employer that is located, but working at a located
Right,
location.
and I think it just gets to the heart of that we need to get access to medical care to
the underserved population.
Exactly, and they're typically more rural.
Yeah, typically.
So there you'll see on the screen the programs that are open. Now you'll see that there's question marks next to at least 6 states. those are the ones that we did not have enough time, or we didn't get response back, actually, if there were any slots available at the time of this presentation. We will get that updated information, update that slide for you before we circulate that.
What is important to know this? Well, because for many of you, well, it's April, which means pretty soon, June, July, we're going to start working with the physicians who we are going to be helping to start filing waivers when the new fiscal comes. New fiscal years comes, which is October 1st. But just keep in mind, some states like Texas, they start taking petitions before October 1st. Texas accepts petitions from September 1st to the end of the second week in September. Usually they fill all the 30 petition slots the first 2 weeks of September. So we kind of, the agencies typically are already kind of getting ready to start cleaning up house to get ready for the new season, but still, all of these programs as of today, they still have J-1 waiver slots available. Some of them may only have a few, others might have more slots. Plenty of them have almost all the slots open. So if you're still out there looking for a J-1 waiver, maybe you want to concentrate on one of these states and check out what is the waiver availability before you start looking for an employer.
Very good. So now let's talk about one of the other J-1 waiver options, which is the Appalachian Regional Commission.
Okay, so the ARC, which is more commonly known by, the IRC waiver is specific to a region. And if you see there on the slide, you're going to see the states that are part of the ARC region. And what you will see is that these states is not statewide. Within the states, there are different regions that are covered, which means that if you are within a region, within the state, within the program, then you can file your J-1 waiver under this program. Or if you select to file it under the J-1 State 30 program, you might have two options. Often what we're seeing with the agencies, meaning the state agencies, is that if a specific employer qualifies for another waiver, for example, the ARC, in addition to the J-1 State 30 Conrad, many times the states will request that employer to apply under the ARC or any of the others rather than using one of the slots of the State 30, because the State 30 only has 30 slots available. This program, the IRC, they are not limited to any specific number of waivers. So if they sponsor 50 waivers, they're fine. They don't have any limitations there. They have the same requirements of the 3 years as the State 30 Conrad, as Michelle mentioned it. The ARC is specific to HIPSA or HPSA, primary outpatient care only. They are very specific. So if you're a specialty, if you're a hospitalist, you will not be able to apply for an ARC waiver. Contracts, the 3-year contract, also a state requires a liquidated damages clause of $250,000. And believe me, when you're applying for the waiver, you're signing the contract, you want to secure your J-1 waiver, but we do have consultations with physicians who want to know, I'm going to have to terminate this agreement for whatever circumstances. What about the $250 liquidated damages clause? Once the agreement is signed and you start executing on that agreement, you're bound by that clause. So you have to agree. And the thing is, you have no choice, because if you want to apply for a waiver under the ARC, you have to agree to that clause. That is a requirement from the agency.
Can't negotiate that, can we?
No, unfortunately. Then you have the DRA, which is similar to the ARC in terms of that is also for a region, Delta Regional Authority. If you see, it includes some of the same states that the ARC has, Alabama, Kentucky, Mississippi, and Tennessee. Again, it's only a state in a specific region. So you have to look at the region to decide whether it's an ARC or DRA. 3-year contract, $250,000 liquidated damages clause is required, no limit number of waivers, but different from the ARC, the DRA, oh my goodness, DRA, Delta Regional Authority, that is open to also specialty. So it's not just primary care, it also allows waivers for specialties, hospitalists in this case. DHHS, Department of Health and Human Resources, HHS waiver, they are not as, they are more friendly or friendlier than most people believe. I've done many of these waivers. Again, we go back to agencies prefer that if you qualify for one of these waivers, that you apply for your waiver under the specific program rather than the state Conrad. It's a federal agency. It is only for clinical care waivers, primary care only, and the HIPSA has to have a score of 7. So it requires a HIPSA, primary care. It is designated for public health centers, rural health clinics, or tribal medical facilities that might qualify for as federal qualified health centers, FQHCs. 3 years contract and proof of recruitment is required, as it is for all the other options or programs that we mentioned. One thing that is good to know about this HHS, yes, it's for primary care, clinical waivers. However, they do accept specialty physicians as long as the physician completed the residency program no more than 1 year before the employment is to start. So if you are, for example, in a fellowship and you are applying for a waiver that will start 1 year after you started your fellowship, then you will be able to apply for it. That might mean that you might have to interrupt your fellowship, because most fellowships are for 2 years. But you have to be within that year. Otherwise, you will not be able to obtain an HHS waiver if it is in a specialty.
Okay, and this one is a great one. This is Department of Veteran Affairs, the VA option. This J-1 waiver option is for primary care or specialty. The interesting thing about the VA is they handle their own waivers, generally speaking. You won't get a lot of assistance from a private attorney on the VAs because they like to handle this. But a couple of things you should know. There is a 3-year work requirement by USCIS that has to be in there, but the VA will issue 1-year contracts. And so those have to be obviously renewed and documented and to show that the span of the work will cover the full 3 years to meet the J-1 waiver requirements.
Yeah, and it's not as much as contracts. Actually, the VA doesn't offer contracts. They just give an offer letter.
Offer of employment.
Yes. The thing is that once the person signs the letter, it becomes a contract. But they will never offer a contract, always a letter. And we have physicians that come when they consult with us asking about, well, don't I need a 3-year contract? Well, in general, yes, but because the VA is a federal agency, they by law can't do contracts with anybody, individuals. They just do 1-year offer letters. The other thing that is interesting about the VAs is they do their own waivers, but usually they outsource the H-1Bs. Yes. So we have been hired in some cases to do the H-1B, but after the waiver has been approved.
Which is a little peculiar, but the other added bonus is that there are unlimited numbers of waivers per year, which is really great for a department like Veterans Affairs. So right here on your screen, you should see a J-1 waiver comparison chart. This is a great comparison chart for a quick reference. You'll see the programs there, and once you start looking at the requirements, you can start looking to see which one will fit your needs to look at one of these J-1 waiver options. Mm-hmm. So we'll continue on now. Angela, please share with us, what are the physician obligations now? We have the waiver, what happens?
Okay, so the obligations, as we mentioned, the main one and the one that every physician should consider when they decide I want to do a waiver is the 3-year contract. They are subject to working the 3 years, full 3 years. Again, it's a full 3 years. I had physicians who come and say, well, but I'll be done by a certain day. Well, you're going to be short by a couple days. Forget it. You have to have the full 3 years in to be able to complete the requirement. Working in H-1B status. H-1B status, that's the visa. The way we best explain this is for the J-1 waiver allows physicians to stay in the United States so they don't have to go back home or last place of residence. But the H-1B is the one that allows them to work in the United States. Without the H-1B, they wouldn't be able to work. Without the J-1 waiver, they wouldn't be able to get an H-1B unless a Canadian physician. So status for full 3 years as a H-1B is required. Must be an employee. That's the nature of the H-1B visa. It's an employer-employee relationship. No contract work or individual cannot be a contract or independent provider. It has to be an employee, W-2 employee. Cannot change. The J-1 physician who obtains a waiver cannot change employers during the 3 years obligation unless they are able to demonstrate extenuating circumstances. For example, termination by the employer, practice closed, employer for some reason failed to meet the employment obligations or is not able to meet them. Personal reasons usually are not valid for a change of employer as an extenuating circumstances. I'm going to give you a couple examples. Sometimes we have physicians who are married to physician. So a physician finds a job at state A, and the husband or wife finds a job in state B. Physician A obtained a waiver, knowing that the possibility of the spouse going to a different state was pretty much 100%. Mm-hmm. And then once the spouse finds a job, and we had actually these are consultations we had. Yep. Clients or physicians come to us asking, well, can I terminate the employment because I want to move to the state my husband or my wife is going to be? I don't want to stay where I got my waiver. The Department of Immigration is not going to consider that extenuating circumstances, precisely because it should have been anticipated. Extenuating circumstances is defined as is a circumstance or something that happened that was not foreseen and it was not caused by the physician. So I have no control over this. I was not able to foresee that this was going to happen. And it is almost impossible for me to continue to work with this employer or in this place for specific reasons. For example, allergies. I had a case once where one of the family members, a child of one of the physicians, developed a very severe case of allergies. And it was because of the region they were living, so they had to move to a different state. That was health reasons. And the physician was allowed to move to a different state. That's not a personal circumstance, that's a health issue. The physician cannot become a permanent resident until waiver service, meaning the 3 years are completing. So the perfect example is physicians come to us and say, I want to start my green card process, and we can start the green card process. We can start phase 1 or 2, but to complete the process, to actually get that green card in their hand, the physician has to wait to complete the 3 years, file the additional documentation with the Department of Immigration showing they met the 3 years so that they can move forward to complete the green card process. Finally, employer and physician, and this is key, and you must keep this in mind, employer and physician are required, not every state, because there are very few states that they don't really care much for this one, but most states and the other J-1 waiver programs, they do require physicians and employers to file or to submit periodically every 6 months or once a year or whatever they feel this fits their program, statements attesting as to the compliance of the J-1 physician J-1 requirements.
Very well. So, in going all over the J-1 waiver options, what is a J-1 waiver or a physician's timeline in trying to do this? And we're going to start with the employer and the physician file the J-1 waiver. At that point, the interested government agency is going to issue the recommendation to the Department of State. You'll see there we're seeing an average of about 4 to 6 weeks. After the Department of State takes that request, they will turn around and then go to USCIS and issue their recommendation. Now, that is still holding about 2 to 3 months. That is still holding true because there is definitely a dedication to running through this program. We're not seeing backlogs there like you might be seeing with other immigration processes with USCIS. After that, the final thing is going to be USCIS is going to issue the final waiver approval that I-612 in 2 to 3 months. Now, this is the J-1 waiver requirement. This is not looking at any of this. The option that we mentioned is not looking at the other options that might be available. But that's just to give you a rough timeline about when we start looking, which ties into what Angela mentioned. For example, in Texas, they start accepting them back in September. So you want to take into account where you're going to be in the process when this all finishes. So, Angela, what are some 5 musts that we can at least give our J-1 physicians to take away from?
Yes. Well, the first one, and is the one that we often talk about, is job search. We always recommend physicians to start looking for an employer that is going to sponsor the J-1 waiver immediately after the second year of residency or the first year before completion of fellowship. Why? Because it takes some time to find the employer, do the interview, sign an agreement. And the ideal situation is to have an agreement signed before, in the summer, before the last year of residency or training or fellowship. So you can file the waiver when the time comes, October of the last year or September if it is in Texas or one of the other states. Target employers in HIPSA, MUA, or MUP areas or a flex area. Finalize employment agreement, as I said, by the fall of the final year. We suggest the summer rather than fall. We got to change that. Document recruitment efforts. Most programs require some sort of evidence, some sort of documentation that the employer recruited or had done some recruitment for a physician, not necessarily a J-1, just a US or a physician in general, at least 6 months before the waiver is filed. Others talk about before the contract is signed, but the 6 months documentation. There are other states that are very specific as to the type of documentation they want to see, such as Louisiana and Alabama. They're very specific. And then you have the Delta Regional Program that is very specific as to what the type of recruitment that has to be done. So that is key. I usually start the conversations with my physicians asking, have you talked to the employer about recruitment? Have they done a recruitment? If they haven't, so where are we in terms of time-wise to file the waiver to see if they still have time to do recruitment? And finally, file the waiver as soon as possible. So if what I do with my Texas waivers is I file the waivers by September 1st. I don't want to wait until the second week or September. If I can have them filed on September 1st, I want my waivers the first date available. Many times at the time might make a difference, especially for waivers who process waivers and first come, first serve. I mean, it may make a difference in whether you are second or you're 10. So you want to begin as soon as you can.
Those are a little nerve-wracking.
At times.
At times. Well, so if we're running out of waiver time, can we go over what does this look like for J-1 physicians?
Yeah. So J-1 visa extension. When we talk about running out of time, we are referring to those physicians who might be in their last year. Uh, right now, we're still filing petitions for physicians who are going to complete their training in this coming June or July. And more than likely, these physicians are not going to be able to stay here until completion, and we'll talk about next. But for example, if you want to have a little bit extra time, you might want to extend your J-1 visa to take the boards. Boards, in some cases, are taken in August, others are September, October. I had even had physicians who take the boards in November. So the training program might end in June or July, but then they can stay here until September, October, or November when they take the boards. That right there might be a couple more months. That will allow us enough time to get the J-1 waiver done, the H-1 visa, so they don't have to leave the United States.
But that brings up a good point, Angela. Can a J-1 physician complete their waiver process outside? Say they didn't file the extension, they took their boards, but they're just not done with the process. Can they complete it outside?
Absolutely, and we're going to talk about that. That's number 4. And also, it helps to find programs that are open year-round. Like I said, we're now still filing J-1 waivers, and we listed the states that have programs open. You also have the HHS that is open all year. They can take as many applications as they want. The VA, the Delta Regional, the ARC, those are waivers. You can file your petition anytime. And file the waiver as soon as you can. Now, as far as the question goes, then we get this question as, what if I have to leave, can I come back? So what do we tell those clients?
Well, we tell them they can complete their J-1 waiver process outside of the U.S. There's a misconception out there, and I guess we don't know exactly where it originates from, but people are fearful of leaving the United States, and there shouldn't. We got to remove that fear, because if the J-1 waiver is not completed before the 30-day grace period ends, they have to go.
If there's no way they can stay.
Right, if there's no extension.
And the 30-day grace period, just keep in mind, J-1 visas, when they expire, for example, you say, oh, my program ends on July 17th, to say something. Normally they don't end at odd days. It's usually at the end of the month or something like that. So, okay, my program ends on July 17th, and then you have 30 days to August 17th to still be in the United States in legal, lawful J-1 status, to do something, file an H-1B, file change of status, do something. But if you're not able to do anything with those 30 days, after 30 days, then your status ends, and you have to leave the United States. So same with if you get to file the H-1B visa.
Right, so you file the H-1B visa. What we try to remind physicians is that process continues. And even though you may not obtain the H-1B change of status while you're in the United States, we send the H-1B for consular notification. You go through the consulate of your home country, or wherever you're processing through, and they'll issue you the H-1B visa. You come back in and you start working on your J-1 waiver period on that H-1B. So all is not lost, right?
Yeah, and it may be a matter of a few months, because yes, you have to wait outside until the waiver is completed. And then you have to wait outside until the H-1B visa is approved. The difference between doing it in the United States, as Michelle mentioned, is that if you're in the United States, you can tell the Department of Immigration, I'm in the United States and I want you to change my status from J-1 to H-1B so you don't have to leave. But if you're not in the United States, or you know you're going to have to leave, then you file the same H-1B, but you tell the Department of Immigration, I will be, or I am outside the United States, that specific country, here is the consulate I will be going. So when you approve my waiver, let that consulate know, because I will be going for my H-1B visa there to come to the United States to work. And it might be a few months. Why months? And we're not talking years. We're not talking you leave and now you have to stay outside for 2 years, because you have to allow for the process to run its normal course. If you have way through the J-1 waiver, it might be 2-3 months before you see the final approval. Then you can file your H-1B, and if the premium process is
Available.
in effect because we know they have suspended it in the last couple of years at times. Then you can premium process the H-1B. Once you get those two approvals, J-1 waiver, the final approval by the Department of Immigration, and the H-1B, then you go to your interview. You get your visa stamp, and yes, I know there are countries where visa stamps are not so expeditiously approved or issued. They might take extra time to issue a visa. And if you're from one of those countries, well, maybe we want to think alternatives, but you'll have to go get the visa where you need to go to return to the United States.
And what we tell the J-1 physicians is at the end of the day, you have to have that H-1B and you have to be in H-1B status to start your J-1 waiver. So if there's a delay by a couple of months, it may not be ideal for your situation, but it's definitely keeping you on the path.
Exactly. And it mainly depends on how soon you file your waiver and how soon you found an employer. The longer you wait to get that employer in place, that employment agreement, the higher the chances that you might need to leave the United States for some time before you come back with your H-1B visa.
Perfect. So let's talk about H-1B. H-1B physicians are those who've completed residency or fellowship. They're going to be the physicians. It's a specialty occupation. So H-1B is really just a give me because you have to have a medical degree that's definitely beyond a bachelor's degree. So the J-1 physicians, this is where you're going to carry out your waiver. You have to carry it out in H-1B status. The J-1 physicians who obtain hardship or persecution waivers and seek employment will also complete this period or hold H-1B status. So we just come off H-1B cap season. Just to refresh your memory, quota is 65,000 for new H-1B visas fiscal year, October 1st, like we see with a lot of things going on in immigration. There's 20,000 that are allowed for master's degree and higher. The H-1B cap is it's no longer first come, it's a lottery. But then we also have H-1B cap exempt. And so there is no limit. You're not going to see that 65,000 quota or that 20,000 quota. That one's going to be permitted for cap exempt employers. So how do we avoid the cap and cap exempt employers? Now, this is an area that has gotten a lot of attention in the last 2 years, and we've worked heavily with employers that have traditionally been cap exempt and where that's been challenged. So cap exempt is going to be, there's listed right there, universities and nonprofit organizations affiliated with post-secondary educational institutions, universities, colleges, college campuses. Government research organizations, they'll also allow nonprofits that are affiliated with these government research organizations or institutions. The for-profit employers is going to be where, and again, this is a recurrent theme, where they're placing the physician at a nonprofit university-affiliated facility for at least 50% of the work week. We've had to document the work percentage of the work week in several cases. So basically, as long as we can defend with the information and evidence available and your cap exempt employer, you definitely want to file under cap exempt. There's no limit, and we could do it at any time. We don't have to wait for that October 1st opening for fiscal year. Physicians who are beneficiaries of the waivers, again, this is where you're going to carry out your J-1 waiver period. That 3-year commitment is going to be while you're in H-1B status.
Yeah, but here we need to make the clarification, and that's why we're talking about H-1B cap, because for some J-1 physicians who obtain waivers, it makes no sense to talk about H-1B cap. J-1 waiver physicians who obtain a waiver through the interested government agencies. What waivers are these? We talked about the State 30 Conrad, the VA hospitals, the
Health and Human Services.
Yes, the HHS, the ARC, the DRA, those programs not subject to the cap. So means what that means is you get your J-1 waiver and then you file for your H-1B, no problem. Yep, fine. The ones, and Michelle mentioned them before, we're talking about the physicians who obtained Where is it? Because I saw it before. Okay, the physicians who obtained waivers through a hardship or persecution, those physicians are subject to the H-1B cap, which means they can't just file an H-1B as soon as they get those waivers. They have to make sure that the cap is open, that there are visas left, that they can file for the H-1B, because if by the time they obtain those waivers, there are no more visas available because the program closes, it fills up really quickly. Michelle mentioned we just passed the time of the year we will file all our cap cases. Then the physician won't be able to obtain an H-1B visa until the following year. Therefore, he will have to be looking, or she will have to be looking at a different option. Many physicians, what they do is they go on all one visas. Extraordinary ability, that's not the subject of this presentation. And they stay on O1 until they are able to get an H-1B, even though they already got the hardship or the persecution waivers. So that's what you need to look for. Okay, great to have an opportunity. You're not going to be subject to the 3-year Conrad, through the 3-year medical service requirement in an underserved area, but then you're going to be subject to the H-1B cap.
So the period of the H-1B, the initial application, we can request up to 3 years initially, and so oftentimes we do. And you can hold H-1B status for up to 6 years. So the extension will be for an additional 3 years. Beyond the 6 years, there are exceptions to how we can extend you an H-1B status, and those exceptions are available. So the 3-year extension is going to be where there's a green card application, but it's on hold. You'll see it for limited availability of green cards. What does this mean? Look at the visa bulletin. If you have an approved immigrant petition and you've held your H-1B and you're at 6 years, but that priority date is still not current, you have to wait, but you are allowed to extend an H beyond that. It's going to be one of the exceptions. There is no specific contract requirement, though, when we file the H-1B, which feels counterintuitive because there's a lot of requirements when we're doing the J-1 waiver, but believe it or not, once we get to the H-1B, it's pretty straightforward.
Yeah, but except when it's a J-1, when you're filing the H-1B for the physician who obtained a J-1 waiver and is subject to the 3-year agreement, contract, you have to have that agreement included in the H-1B. Other than that, there is no agreement requirement. And it's funny because we do get these calls frequently from physicians. I'm done with my J-1 waiver, but now I want to file for my H-1B extension, and I want to know for how long do I have to sign the new employment agreement. And they kind of get taken when we tell them, you don't need an employment agreement for H-1B purposes. You might need it for your employment because in your field and in your industry, the norm is that there are employment agreements between employers and employees, physicians. But for H-1B, other than when you are requesting that first H-1B for the 3 years of your J-1 waiver requirements, there is no employment agreement requirement. Actually, it's funny because sometimes they're so focused on, well, the agreement says 2 years or 1 year or 3 years, and it can be terminated here and there and whatever. And they forget that for immigration purposes, they are subject to whatever the H-1B visa says. So if the H-1B visa says we're asking for a 3-year term, it might be terminated at any time. They don't care if the agreement says you have an employment agreement that you cannot terminate for at least a year. USCIS doesn't, they don't care if it is terminated before that year, because for H-1B purposes, unless you're a J-1 waiver physician, employment can be terminated at any time. The employment agreement can say you're going to be paid, just to give you an example, $150,000 per year plus bonuses plus all of these benefits. And at the end of the day, you only get paid $150,000 a year. That's what the H-1B says. It meets the H-1B requirements. The USCIS does not care if you were not paid the bonuses you were promised or if anything happened with the benefits. That's contract law, not immigration law. So there is where it comes kind of contradicting, because you have these agreements with all these terms, but then you go and you're bound by the terms of the H-1B visa that are very straightforward: salary, term, location. Yep, period, right?
So H-1B portability though. So if a physician's already holding H-1B status and wants to change employers, so we're not, we're basically looking to move over, and what happens? What does this new employer have to do to get this physician over? You file an H-1B petition. Now, the interesting thing is the physician may start employment upon the filing of the H-1B. We often say, wait till we get the receipt notices, and you could move over and wait until and start working with those receipt notices. You do not have to wait for the final approval notice of the H-1B to start working with this new petitioning employer.
Yeah.
Obviously, we recommend best practices to wait, but there are situations that can't be avoided, and that is definitely an option that's available. Concurrent H-1B petitions are permitted, so physicians who like to moonlight, there are no J-1 restrictions.
That means that, for example, if you have your J-1 waiver and then you get your H-1B and you are within the 3 years J-1 requirement, and you have an opportunity to moonlight, and it's this great opportunity, but the employer is not located in an underserved area and is definitely only a few hours per week, then you can do it. You're not subject to working a concurrent employment in another underserved area, because your primary H-1B will cover and take care of the J-1 waiver requirements. Any other additional concurrent moonlighting H-1B, it can be at any location, any employer, for any time, and for any number of hours.
All right, we just remind physicians to focus though on fulfilling the J-1 waiver requirement with your primary H-1B.
Well, that's the focus.
Yes. So, but talk to us more about concurrent employment then.
So concurrent, we mentioned it, and portability. Concurrent is basically you can work with somebody else. At the same time, you're working with your primary H-1B sponsor. Remember, H-1B visas are employer specific. So you can only work for the employer that sponsors the H-1B. If you want to work for another employer, that employer must file an H-1B visa petition for you to be able to work with them. And that's what is called concurrent. The concurrent H-1B has to be filed within the validity term of the primary H-1B visa. And when approved, if approved, is only going to be approved for to the end or for the time that the primary H-1B visa is approved. So the expiration date of your concurrent H-1B is going to be the same date as the expiration date of your primary H-1B visa.
Excellent. So, what about H-1B self-employment? Is that permitted?
That is the greatest thing ever after they messed up the whole program, because initially a few years ago, physicians could open their own enterprise or companies and sponsor themselves through that, and there was not really a lot of difference between doing an H-1B with somebody else and sponsoring the individual and doing your own H-1B. They suspended that. They said, no more self-employment, because that is not in line with H-1B requirements. But later on, to fix it, because they saw the people coming and complaining, and
there's medical practices.
There were a lot. So what they did to fix it was they said, okay, fine, you can open your own company, but then because you have to establish the relationship between employer and employee, then your company has to have the right to control your employment. What that means is your company has to have the right to hire you, fire you, restrict your employment, control your employment. In other words, you have to become an employee of your company, and your company is your employer for all purposes, H-1B purposes. So the way they did, one of the things is you might have a partnership where one of the partner or a couple of partners, they are the ones who have control, and you're just going to be working with. Yes, you will still be a partner, but they're going to determine the scope of your employment. Then also, when you do bylaws, in the bylaws, if you create a board of directors, and again, in board of directors, like some people ask me, can I name my wife and my... No, board of directors is usually independent people who can decide whether or not they want to keep you employed. And board of directors, how many? Well, the law doesn't say how many, but we usually recommend at least 3 people, because if you have 2 people and they have a disagreement, who is going to break the tie?
You want a tiebreaker.
So think about what would be kind of reasonable. And when we talk about board of directors, you cannot have one person. You have to have more than one, ideally 3 or more. And they are the ones who are going to decide whether or not you continue to work. I know this is a concept that is difficult to understand, because for most people, why would I create a company, open the company, do all of these things, and then have the company fire me?
Right, they say we relinquish control, and that's what we have to make the decision.
That's what it is.
You distinguish between ownership versus employee-employer status.
Correct. Relationship, but believe me, it's being done.
Yep.
We have clients and physicians and many people. They are working locum tenens. It works perfectly for them. Who are working part-time, some of them full-time, based on this self-employed employment H-1B, and it works. You just need to be careful how to tailor the company, the board of directors, the bylaws to meet the requirements of the H-1B visa.
So a couple of loopholes.
Yeah.
So to sum it up, H-1B physician strategic planning. We threw up really 4 quick buzzwords there. I know we're running on time. Number 1, target. You want to go for cap exempt employers. Number 2, finalize. Finalize is going back, take the action on the employment agreement as early as you possibly can, so that you're well within the processing times to get everything done to where you don't have to possibly leave.
Mm-hmm.
Third, you want to document the employer's exempt status, nonprofit documentations, affiliation agreement, active relationship. Again, document your contract, document your terms. Everything has to be documented.
For the active relationship, and we have been seeing these in the last couple of years, and what we are doing with this is when we have companies or organizations that are nonprofit and they have affiliations with higher education institutions, what they mean by active relationship is they don't just have an agreement and it's sitting there. They have an agreement, but also the students from the higher education institution are training or are working or are doing whatever it is that the agreement says in the affiliation agreement that the students are doing. So for that, we often have to include documentation that shows how many students for that specific institution the nonprofit currently has. What is the year of graduation? Often they ask for names.
Yep.
Which I know is supposed to be confidential, but we're talking immigration,
yep.
H-1Bs. So you have to document, not just that you have a document that says, yes, we're affiliated, we're working together, but also who or how many students from that institution you have at your location, a nonprofit location, that makes you having an active relationship. And so you have to have that.
Right. And last but not least, file. So target, finalize, document, and file. And make sure that you do all of these things within a reasonable timeline to where we can accomplish and get your solution.
Yeah. So with this, we're going to go on to questions, answers. For confidentiality reasons, please do not state your name because we want to keep it confidential. Also, please, if you could speak clearly and loudly, because others on the line might want to hear your question, and we will give you an answer. Do we have a couple of questions? Could you please read the question?
Yeah. We have a hospital, so this comes from RH. We have a hospital client in an area of New York that's in the ARC who is planning to hire a hospitalist that requires a J-1 waiver. They are also a Canadian citizen. Are there exceptions for Canadians? Because an earlier slide noted that ARC waivers are for outpatient care only.
For primary care. And this has to do more with J-1 waivers, H-1B than the ARC. Because for Canadians, and we talked about the H-1B, and we've done it, and it's frequently done. H-1B, why works for Canadian? They could obtain an H-1B visa without the waiver, and it works for people from Canada because, remember, people from Canada, because of the NAFTA, well, that's changing the name as soon as it is ratified, because it was, we're not going to talk about that one today, but that is where this comes from. People from Canada do not need visas to come to the United States. Therefore, they are not subject to applying for a visa at a consulate. If they have to go to a consulate, the first thing they're going to say is, what is your waiver for giving them an H-1B? Because they don't have to do that. Then they can come through the border. And border means driving through or at an airport and show that they are from Canada, they have a Canadian passport, and that they have a J-1, an H-1B approval, and they let them in. So the physician does not need that waiver to be able to come to the United States in the H-1B visa. So yes, you could sponsor the H-1B visa, but if the physician needs a waiver and it doesn't qualify for the ARC waiver, then you might need to start looking at the state 30 Conrad waiver. So initially, to get the physician working, you could do the H-1B, but please file the J-1 waiver under the state 30 program as soon as possible so that the physician eventually can change the H-1B without waiver to H-1B with a waiver, and also apply for the green card, because as long as the physician doesn't have the waiver or can't prove that he resided outside for the 2 years, that physician will not be able to obtain a green card. And ultimately, that's what they want.
Yeah.
Okay. Let's see. We're going to unmute so that if people have a question, they can ask it.
Okay, we're going to
But if
unmute.
they would, in the app, go ahead and just raise their hand in the attendee section if they have a question to ask.
In the meantime, I got another question that came in earlier, and this person was asking for, I have two opportunities. One of them is in a state that only has a few waivers, but there is another opportunity that I have at another state that has more waivers available, although I like the one that has fewer waivers. What if I don't get one of those waivers, or my petition is rejected, or I'm able to file it, but I like the offer and the other state? Can I file both waivers? Well, you can't. The law prohibits that you have two waivers filed or ongoing at the same time. So once you file you one waiver with a specific state or a program, ARC or DRA or VA or any of the other programs, you can't file another waiver. To file the other waiver, you have to withdraw the first waiver, but you can be processing two waivers at the same time.
Okay, we have another question from a listener whose first name is Liang. Liang. How about if I get a job at a university hospital which qualifies for H-1 exempt? Can I apply the H-1B even though they already ran out of the 8,500 H-1B number?
Yeah,
Yes.
That's what being exempt means.
Exactly. That's where the CAP exempt employer really comes in handy, because you do not have to go through the CAP subject, the deadlines and everything. As soon as that sponsoring employer is ready to proceed, we file the H-1B.
Exactly. And so which means that whether the cap is open or is closed, those employers who are exempt from the cap, they can file H-1Bs at any time of the year, as long as the exempt nature of the employer is documented.
Right.
We talked about the nonprofit, so you need the letter, or if it is a university, so you need to prove, well, yes, this is the university, and I'm going to be working with that. As long as it's documented, the H-1B can be filed at any time.
And there's a follow-up question. Can the TN visa be used for resident training?
TN, they're tricky because TN visas can only be used for physicians doing research.
Yep. So to answer your question,
for researchers, it might work, but any other type of employment, it won't, because it's specific.
Right, and that's one thing that you have to check on the special occupations. Most folks find, especially Canadian or Mexican physicians, will see that they have to pay attention to the fact is it's for research purposes.
Yes, and the TN, remember, there's a list of occupations. And if your specific occupation is not listed on that list, again, they list physicians, but only research.
Yes.
So
some folks miss that detail.
Yes, yes. So it's not all physicians, it's research.
All right, we are going to unmute. No, hang on, I want to make sure it works. Okay, well, we're trying to unmute. It looks like we have another question, so hang on. This question comes from a listener, first name with Lou. How difficult is it to obtain an O1 visa? How extraordinary do I need to be to be eligible for O1?
For O1. Well, we honestly, and I'm going to let Michelle go into this one, but honestly, we never refer to petitions with the U.S. as difficult or not difficult, or easier or not, or whatever. An application is application, and the requirements are the requirements. So we focus on whether you meet the requirements or you don't. And the process is the same for everybody. But how extraordinary you have to be, Michelle?
It depends. Well, no, extraordinary, it has to be well documented. There are certain categories of evidence. What we normally do is we recommend the consultation and that you send over a full, completed CV or resume that lists all publications, all mentions, citations, poster presentations, experience, lists everything under the sun that you would want your mom to tout around and brag about you.
Yeah.
That is what we look at as for our initial analysis. Then we go against the O1 requirements, which is actually really a whole other presentation, but there's got to be extraordinary ability. You have to be recognized in the field. There's a lot of ways we could accomplish that, but the first step is evaluating the CV, and we'll give you our honest assessment.
Yeah, and let me give you a couple examples. Extraordinary ability, the requirements are either you won a major international award, Nobel Prize.
Nobel Peace Prize.
Yes, and not many of us get those. Or you meet 3 of 8. So, and those 3 can be articles, publications. They even mention salary. And on salary, we always tell people, be careful with that one. It may be deceiving.
Judging the work of others.
So what you want to do is take a look at your resume. And this is not the time to be modest.
Right.
Like Michelle says, throw everything you can on those resumes. We'll take a look at it. And we look at quantity and quality.
Exactly.
Because if you tell us, oh, I have 100 publications, but then we start looking at the publications and they're really not significant, or you were not even first author, or there's a bunch of different things. Well, 100 publications may not be a big deal. But if you tell us, I only have 5 publications, but they are in the major medical journals that very few get to publish, 5 might be enough.
Yes.
So it is a combination.
But it goes back to the point, document. So your resume is the first step. We look at it. If we see that, on the face, it looks like you'll meet the requirements. Let's see how well we can document it. Yeah. A well-documented filing that meets all the requirements stands the best chance for approval. Sometimes you have to go back and remind CIS that we're right, but oftentimes we'll be able to secure that. The O1 is actually one of my personal favorites, so I would love to look at your resume.
Yes, send it over. We'll take a look at it. and don't be modest. And you never know, because there are many things that can be used, and it's a combination of the totality that makes you extraordinary, not just one or two things.
Hello, Angela. This is not the time to be meek.
Yeah, and I love when I can tell physicians that they don't need to be modest. You can throw it everything.
All right, we're going to try and unmute again. Yes.
Okay, let's make this.
Well, if we still have callers who want to stay, we understand time is of the essence. Please feel free to follow up with us, call us, email us. We'll be happy to talk to you. But if we still have a couple callers who want to ask a question, we can entertain a couple more minutes, and then you can email us the questions. We'll be happy to answer them.
Yeah, I'm not seeing anybody speaking up, and we don't seem to have any further questions.
Great.
So we will be sending slides, and
yes, we will be sending you the recordings and slides. Please, we apologize. We had some technical difficulties at the beginning with the PowerPoint, and I know some slides may not have been shown, but it was resolved. We'll send you a copy of the entire presentation and the recordings. Thank you for bearing with us, staying here. We'll see you on May 15th.
Yes, join us. Please save the date, May 15th. Our webinar will be discussing the e-visas, the treaty trader and treaty investor visas, initials, renewals, and current issues that we're seeing with this particular visa category.
And we just want to give you a heads up, because in June, we're going to be talking about extraordinary ability.
Yes. So
period.
Yes.
So everything that you want to know about extraordinary ability visas, right?
Right. And please don't forget to subscribe to our newsletter if you want to stay abreast of the current and upcoming webinars that we have.
Great. Thank you so much. See you in a month.
See you next month.